We're going to jump into our In the Weeds. So Jared Richards and I don't know if we met. We talked last year. I think Jared is a very rare individual because he's an attorney who is an entrepreneur. You won't find very many of those in my experience. And he started a company, co-founded a company called Bluehouse Skis. They're a niche downhill ski manufacturer. Really cool stuff. But he's also an attorney at Bennett, Tueller, Johnson, and Deere. And they've offered to help, multiple times with LaunchUp. And what we thought we could do tonight is delve into some things in the weeds. And what we want to talk about, is 6 legal startup issues in 9 minutes is the presentation. So, Jared, if you come up and give us some good advice.
Thanks. I'll do my best, and thanks, Steve, for the segue, because we're going to talk about that issue as well real quick here in just a moment. And Jeremy, you may not know, but Bennett Tueller is a firm of entrepreneurs, which is kind of crazy, and that's why it's a good fit there. So anyways, here's the 6 points we're going to talk about real quick. These are questions that we get over and over from startups, and we're going to touch rules of thumb today on each of these. First thing we hear most often is choice of entity. I just started a company. What kind of company do I want to form? As a rule of thumb, hey, if you're a real VC niche company, you're going to be raising money, you fit that model, skip the guesswork and go straight to a corporation. Form in Delaware and have yourself a nice Delaware C corporation, because if you don't, you're going to have to get there eventually when the VCs demand it. Next, if you don't fit the VC model, and you don't fit the VC model, you're going to run a lifestyle business with a couple buddies, the LLC is a great form. It's cheap, it's flexible, you can write all the rules of your entity, and it's nice and easy that way. An S Corp, some of your accountants might force you into an S Corp for certain tax reasons, and that's okay too. The S Corp is hard to invest in because outside investment entities can't invest in them, but individuals can. So if you're approaching an angel, they can still get the flow-through benefits of an LLC and an S Corp, and then later down the road, when you need to raise VC money, you can turn the S Corp into a C Corp very easily. Last, Delaware versus Utah. Again, the reason why corporations form in Delaware so often is that's what venture capitalists like, because they feel comfortable there. There's a base of law that's made them feel comfortable because they know they're protected there. Last but not least, a lot of companies, they get off the ground before they've actually formed this entity. If you're signing agreements or making any commitments in the name of this company before it's formed, you are missing out on one of the biggest benefits of the entity, which is this limited liability. Instead of the corporation bearing that liability, you're bearing it individually. Next, relationships. We just talked about, we heard about this IP. There are 2 issues that we see most often mucking up a deal or an exit, and they usually happen in the first 6 to 9 months of a company. And they usually either have to do with founders or intellectual property. So first, let's talk about the founders. 3 buddies form. They got a great idea. Then all of a sudden, one of them, he sells out and goes to law school. That's what one of the partners usually always does because he thinks it's a safer route. But now all of a sudden, what are you going to do with them? You're in early stage, you're pre-revenue, you don't know how to value them to get out. Well, this is where you can set the ground rules. In an LLC or a corporation, both of them, you can have restrictions on your membership interests or your stock. And so you can say, first things first, let's prove ourselves. So let's see what you can contribute to the company. So instead of owning all your stock outright at the beginning, we'll say you get a portion after a year, you get a little portion each month after you've proven yourself to the others. And this is standard and simple. And the most savvy entrepreneurs who come to our offices, they always ask about this first thing. So this is an issue you should ask about, vesting with your other founders. This also talks about situations where if somebody leaves prematurely, well, some of their stock gets to come back to the company that you don't have to pay for, and then you can agree on one of these formulas like Steve talked about to buy back the rest. This is very favorable to the company and helps them when they need to go raise other money and they've got those shares back from this founder who leaves. The other happens is, okay, founders started working on an issue. They got 9 months into a problem, and they haven't formed their entity. They haven't issued any stock. And then one of them disappears. He says, oh, I don't see the vision anymore. You never sign any agreements, no documents ever exchange hands. And now you're ready to exit. You're getting ready to sell, and your buddy hears that you're selling your company for $20 million. And he's like, oh, that's so awesome. I'm so glad I can participate in that. And you're like, well, I know you helped out for a few months, but you don't own any of this company. He's like, oh, yes, I do. And now you've got some common law partnership problems. He may have some claim to the company. He may have some claim to the IP because there was no documents in place. And so in order to avoid him coming and holding you hostage on the eve of a nice deal, whenever a founder leaves, one of your buddies leaves, make sure that you have at least a little letter from him saying, hey, I'm doing other things. This is voluntary. I'm relinquishing my stock. I don't own any ownership in the company or any rights to the IP. And if I did, just if that happened, then I'm assigning them all to the company. Really easy thing to do. Last but not least, setting expectations in a company will make the relationship between those individuals a lot smoother. You can do this in an operating agreement, employment agreements, and shareholders agreements. It makes that relationship understood from the beginning so you don't have to address issues when it's harder down the road.